Continuing with part 2, also in 1999 from Insight magazine, has psychiatry gone psycho? When a child has been sexually abused and feels guilt about it, Gardner suggests the child may be helped to appreciate that sexual encounters between an adult and a child are not universally considered to be reprehensible acts. The child might be told about other societies in which such behavior was and is considered normal. If sexual urges continue after the abuse ends, Gardner suggests such children be encouraged to masturbate. Gardner suggests that the molesting father's behavior should be understood. The father has to be helped to appreciate that even today, pedophilia is a widespread and accepted practice among literally billions of people, and he has had a certain amount of bad luck with regard to the place and time he was born with regard to social attitudes towards pedophilia. By 2001, it was noted in Family Legal Quarterly that PAS also has been asserted in cases involving other types of abuse and in situations in which a child refuses to visit a parent for other reasons. See Carol S. Bruck, Parental Alienation Syndrome and Alienated Children, Getting It Wrong in Child Custody Cases. Carol S. Bruck is a professor of law and chair, doctoral program in human development, University of California, Davis. More information about parental alienation syndrome from the Justice for Children website, which looks like this. Justice for Children is a national children's advocacy organization that has assisted children whose lives have been adversely affected by the use of PAS in court. It is the position of Justice for Children that PAS is junk science. Tim Burton notes that PAS is not just junk science, it is dangerous science. Reliance on facile diagnosis of PAS in custody decisions puts abused children at extreme risk of further abuse because PAS encourages courts to discount, even ignore, a child's allegations of abuse without proper investigation. Under Gardner's theory, a child's outcries of physical or sexual abuse against one parent are seen merely as the product of alienation by the other parent. Therefore, courts relying on PAS frequently fail to investigate the child's allegations, and they may even reject independent evidence of the abuse. That is exactly what happened in Tim Burton's case. According to Gardner, the children should be completely removed from the alienator's influence. All contact between the alienating parent and the child should be cut off, and the children should be deprogrammed. According to Gardner, the only way to counteract parental alienation is to place the child in the sole custody of the alleged abuser and severely limit or even totally prohibit contact with the alienating parent. Thus, the child is delivered into the hands of the abuser and cut off from any outside protection and support. It is hard to imagine the confusion and hopelessness experienced by such children. Tim Burton requests the court to address the scientific validity of PAS or lack thereof and conclude that PAS is junk science. He requests the court should hold that PAS evidence should not be admitted because it is not generally accepted in the scientific community, it is inherently unreliable, and it endangers children. On May 25, 2003, Richard Gardner committed suicide. He was at his home in Tenafly, New Jersey. He was 72 years old. Richard Gardner died a gory, bloody, and violent death from his own hand. Gardner took an overdose of prescription medication while stabbing himself several times in the neck and chest. Gardner plunged a butcher knife deep into his own heart. The Bergen County, New Jersey medical examiner removed the knife from Gardner's chest and listed the stabbing wounds as the cause of death. On June 9, 2003, the New York Times printed his obit. On June 14, 2003, the New York Times printed a correction, noting that Gardner had not actually been a professor at Columbia, but had been in an unpaid volunteer position. Following Gardner's suicide, attorney Richard Ducote, who was the last attorney to cross-examine Gardner, stated that in a Florida case in which they had recently been involved, when the judge insisted on a Fry hearing, Gardner simply did not show up. Ducote speculated, and his speculation certainly seems reasonable, that perhaps Gardner finally realized that the entire nation was onto his scam. As a farewell to Gardner, Ducote said, "Let's pray that his ridiculous, dangerous PAS foolishness died with him." In 2006, the National Council of Juvenile and Family Court Judges published their semi-annual guidebook, Navigating Custody and Visitation Evaluations in Cases with Domestic Violence, a Judge's Guide. The guide includes a section on the admissibility of parental alienation syndrome testimony in custody hearings. The 2006 Judge's Guidebook clearly states, Richard Gardner's theory positing the existence of parental alienation syndrome, or PAS, has been discredited by the scientific community. Testimony that a party to a custody case suffers from this syndrome should therefore be ruled inadmissible both under the standard established in Daubert and the stricter Frye standard. The Justice for Children website puts it simply: the National Council of Juvenile and Family Court Judges has a position that PAS is not to be used in court. This Council of Judges has deemed that the evidence against the existence of PAS is sufficient enough to throw out the concept entirely. Hopefully this will bring some justice to those who have been unlawfully accused of this imaginary and outrageous syndrome. In 2009, the National Council of Juvenile and Family Court Judges issued a word of caution. Under relevant evidentiary standards, the court should not accept testimony regarding parental alienation syndrome or PAS. The theory positing the existence of PAS has been discredited by the scientific community. In Kumho-Tyre v. Carmichael, the Supreme Court ruled that even expert testimony based in the soft sciences must meet the standards set in the Daubert case. Daubert, in which the court re-examined the standard it had earlier articulated in the Frye case, requires application of a multi-factor test, including peer review, publication, testability, rate of error, and general acceptance. PAS does not pass this test. Any testimony that a party to a custody case suffers from this syndrome or parental alienation should therefore be ruled inadmissible and stricken from the evaluation report under both the standard established in Daubert and the earlier Frye standard. It is manifestly unjust that the use of this bogus syndrome has been instrumental in Burton's case as the primary vehicle and the only methodology to justify the loss of custody and a severe limitation of the petitioner's rights. PAS is touted to be an accepted psychological syndrome when in fact it has no scientific foundation and has been routinely rejected by courts and mental health professionals as admissible in the courtroom. Nonetheless, PAS is still being used by unscrupulous attorneys and hired gun experts to attack the credibility of parents, usually mothers, and undermine the testimony of little children who have accused their fathers of unspeakable acts of abuse. It is evident that PAS has been relied upon in Burton's case, and it is and was incumbent upon respondent and his counsel to investigate the validity of their allegations. The use of PAS in this case as a sword and a shield is reprehensible. The respondent has used this theory to defend himself and simultaneously attack his ex-wife as an alienator, rather than examining his own behavior to determine why his children said certain things. Tim Burton notes that the respondent and his attorney should be sanctioned for bringing bad faith allegations and for basing their case on this junk science. The next major revision to the DSM is expected in 2013, the DSM-5. There are some fathers' rights groups who are mounting a letter-writing campaign to have PAS included in the DSM-5, which is ridiculous because the DSM is based on research, clinical test, and professional judgment, not letters of opinion. Dr. Kaplan today has more information. The website looks like this. Update for the article about parental alienation syndrome. DSM-5 head writes us that PAS will not go in the manual. Dr. Kaplan states that on June 9, 2011, he was one of 3 recipients of a letter from DSM-5 Task Force Chair David Kupfer and DSM-5 Task Force Public Representative James McNulty. The news in their letter is that because of the high evidence threshold required, the task force is not currently recommending the inclusion of parental alienation syndrome in the DSM-5. Dr. Paul Fink, former president of the American Psychiatric Association, has stated, Dr. Gardner and PAS should only be a pathetic footnote in psychiatric history. Gardner and his bogus theory have done untold damage to sexually and physically abused children and their protective parents. PAS has been rejected by every reputable organization considering it. Resources used in this video include Tim Burton's brief is available at www.justiceforchildren.org/amicusbriefs.asp. More amicus briefs are available online from Justice for Children's Legal Resources page, from the Leadership Council, and other national children's advocacy groups which are easily found through a Google search for DV by proxy, amicus. The Bergen County Medical Examiner's Report, and also the last attorney to cross-examine Richard Gardner, is at cincinnatipas.com/richardgardnerautopsy.html. The Wikipedia article is at wikipedia.org/wiki/Richard A. Gardner. Richard Gardner's obituary at The Independent is at www.independent.co.uk/news/obituaries/Dr-Richard-A-548246.html. Thank you for watching, and may we come from where we are right now to the best interest of the child.